The America First Legal Foundation, combating the left's radical agenda.
Fight for the American people, defend the Constitution, and save this nation for the next generation. Hey everyone, welcome to this week's episode of The Arena with America First Legal. I'm Gene, president of America First Legal. I'm joined today by our general counsel, Julie Strauss, and our very special guest, the Honorable Assistant Attorney General for the Civil Division, Brett Shumate. Brett, thanks for joining us today.
Thanks for having me. It's great to be with you.
So one of the things that we like to do here, very much initially, at least when we have new guests on the show, is to say, hey, Brett, what do you do? Who are you and what do you do? It's almost, do you remember, what was that movie Arnold Schwarzenegger was in? Kindergarten Cop. Who is your daddy and what does he do? So who are you and what do you do?
So I run the Civil Division at DOJ. And so the Civil Division is basically handles all civil litigation for the United States, except for certain subject matter areas like environmental, antitrust, and civil rights. So all other civil litigation falls under my responsibility. So Civil Division has about 1,000 lawyers, about 20 political appointees who help run the front office. And my responsibility is to manage the division, make sure we're making the right arguments, defend the president's priorities, aggressively enforce the president's priorities to the extent we're doing enforcement work. So that's what I do on a day-to-day basis is litigate cases. Probably 90% of what we do, Gene, is like defensive work, defending the United States against lawsuits seeking to enjoin executive orders or agency rulemakings or tort claims against the government, whatever the case may be, breach of contract claims. A lot of non-controversial stuff. The stuff that you hear about in the news is typically in the civil division cases where president issues an executive order on birthright citizenship, for example. That's the civil division that defends those cases in the district courts around the country and the courts of appeals. When it gets to the Supreme Court, we hand it off to the Solicitor General's office. But we're involved in those cases from start to finish. You can kind of think of the civil division as a holding company of seven different branches that make up the division, from federal programs, which defends all the high-profile challenges, appellate, torts, immigration. We now have tax. We have an enforcement branch, and we have missing one of our branches, but I'm sure it's important as well. Commercial litigation.
Commercial litigation.
All financial claims against it.
Yeah, absolutely. So how do you... People might be familiar, some of the lawyers, some of the law students across the country, they might be familiar with the fact that we have different U.S. attorneys' offices all across the country. So how does your work interact with the local offices across the country? How does Maine Civil from Maine Justice interact, and how do you guys decide which kinds of cases to handle exclusively out of D.C., exclusively in the field? What does that look like?
Great question. Probably the bulk of the civil litigation in the United States, the routine cases, is handled by the U.S. attorneys' offices. Maine Justice, the Civil Division, we will handle the most important, most high profile, the ones involving the most money. And so when a case is filed against the United States, it's a civil case, the plaintiff will serve the U.S. Attorney's Office for whatever district it's in. That gets forwarded to Maine Justice, and then my office will make a handling decision. Is this sufficiently important that we need to handle it out of Maine Justice because it implicates a White House priority or an agency rule that is very important to the agency? Or is it a more kind of routine case that we can delegate out to the U.S. Attorney's offices? So sometimes we jointly handle with the U.S. Attorney's offices. Sometimes we monitor their cases. And other cases like birthright citizenship or the big programmatic cases, we will handle at Maine Justice. But it's really a partnership with the U.S. Attorney's offices because they're handling a ton of cases. They come to us for guidance in certain areas like tort claims against the government. We have a lot of expertise that we can help show them template briefs where we've handled this type of case before, provide guidance to them. They come to us, certain approvals or settlements that need to get approved by Maine Justice. So we're kind of like a clearinghouse for all civil litigation, but a lot of it we push out to the field across the country.
So for those who are non-lawyers, which thank goodness are most of Americans, right? They're real Americans, as I call them. I get a sense that they don't really understand what is the Department of Justice on a very basic level of how does DOJ affect my life? Are they there for me? What is it that DOJ does how would you explain it to them in a really sort of understandable way for their purposes.
I would explain it as DOJ is like the law firm for America. The main thing that DOJ does to keep America safe is prosecute federal crimes. So a lot of the criminal prosecutions around the country happen at the local U.S. attorney's offices level. Main justice handles more complex investigations and criminal prosecutions. But any legal or litigation service that the United States needs is handled by the Department of Justice. Now, all the agencies will have their own legal counsel or general counsel's office that are more like in-house counsel, like a corporation would have in-house counsel and they hire outside counsel. But DOJ's role is really to represent the United States in court, whether that's prosecuting federal crimes, filing civil enforcement actions, or defending the United States whenever somebody has a claim for money damages or somebody's hurt and sues the government. Any type of litigation involving the United States almost exclusively will be handled by the Department of Justice.
And that's a great way of explaining it. And I know, for example, that in the last administration, AFL sued the State Department, and the Department of Justice was the outside counsel, if you will, representing the Department of State. So that's very, very logical. So I know the False Claims Act and Medicare fraud and other related cases are very much in the news. And I think people have seen Nick Shirley running to, different cities. And what was it? The not the Learning Center, the Learning Assessment. Exactly.
Absolutely.
Talk a little bit about that, because I think people will really relate to the fact that there are fraudsters out there that have ripped off the government. And I know that this is something you've been working very much on.
Fraud is a huge priority across the administration. We have a new National Fraud Enforcement Division. The Civil Division has a piece of the kind of fraud enforcement work, and that's the Civil False Claims Act. And so the Civil False Claims Act is a statute that allows the government to recover money civilly when somebody makes a false claim against the government. We can bring it's a civil suit. Oftentimes there are private parties can file those cases, and the United States can intervene in those cases. But the False Claims Act prohibits false claims against the government. So there may be egregious fraud against the United States that can be punished criminally if there's the right kind of the elements are met to punish somebody criminally and prosecute them. But oftentimes you have companies who defraud the United States, healthcare companies, for example, who make mistakes on when they're billing the United States or Medicare or Medicaid for reimbursing for healthcare services that they provide. And oftentimes there's fraud involved. This doesn't rise to the level of criminal fraud, but they make false claims. And the False Claims Act is a really powerful tool to recover fraud for the United States because there are triple damages under the False Claims Act. So if there's $100 million fraud against the United States committed by an insurance company, we can triple that and recover $300 million for the United States. So it's a very powerful tool. And the types of cases we go after are big kind of healthcare fraud schemes, where insurers or healthcare providers are making false claims, providing services they're not actually providing. And we work closely with the criminal division to make sure we're handling each case correctly. Like some cases, maybe there's evidence of criminal fault, and we let the criminal division take the lead, and ultimately that case might resolve with a criminal prosecution. Other times, the criminal division says, civil division, you take the lead because that's more of a civil matter. So then we'll take the lead.
Right. And those are the kinds of cases that really do affect Americans, or everyday Americans.
They certainly do. I mean, last year we recovered over $6 billion just under the False Claims Act, which was a record year for the Department of Justice. Typically, we bring in and recover $2 to $3 billion a year. $6 billion was a record year last year, and we'll see what the numbers say for this year.
I suspect there'll be more.
So much fraud.
Yeah, I mean, there's just so much fraud. It's all over the place. I mean, the False Claims Act has been around since after the Civil War, right?
Right.
I mean, this is not as though there's some new tool that is being used by the Trump administration. It's just actively being used because there's so much fraud that's out there. And there's so much, I suspect, based on my experience and observations, some of the stuff may be mistakes, right? There could be mistakes that people make, and the amount, the volume really rises to the level of significant money over a period of time. But a lot of it is intentional. And a lot of it is really going to be a matter of whether the government can prove the intent from the requisite actor to take criminally as opposed to going civilly with the False Claims Act. Can you give an example, hypothetical example? I'm not going to ask you for anything real, but if you're an average day American and you're working at a corporation and you're aware of fraud that's ongoing, that's fraud upon the government. So there's a contract, whether you're a defense supplier, you're a medical supplier, you're something, and you have a contract with the government and you know that there is fraud that's ongoing. What are some practical steps that a person could take to try to correct the decision or to at least notify people about the existence of the fraud in the first place?
Right. This happens all the time, Gene. And we really value whistleblowers at companies who see fraud, ring the bell, and oftentimes are retaliated against. And you know, what individuals in that situation can do is gather evidence, and they can file what's called a qui tam, or file a private party lawsuit against the company that's filed under seal, and then the United States will investigate whether there actually was fraud committed against the United States. So the best thing that somebody in that situation can do is ring the bell and gather evidence, and you can hire a lawyer and you can file a case and you can file it under seal and nobody knows about it until an appropriate time after the Department of Justice has an opportunity to investigate. And if there's real fraud, then the United States can intervene. And oftentimes we settle those cases. And one of the incentives for whistleblowers is there's a financial award to whistleblowers who bring successful cases, up to 25 to 30% of a financial recovery, which can get into really large numbers. Like, I approve these settlements all the time. I think I just signed a memo in the past week for a $40 million relator or qui tam share to somebody who was a whistleblower.
Wow.
Just an ordinary person who saw wrongdoing at a health insurer or a healthcare provider and blew the whistle and protected the United States from continuing to suffer fraud and helped to recover hundreds of millions of dollars in fraud.
That's a really important point. I think a lot of people are afraid to come forward. And so what you just said in and of itself is encouraging, I think, for people. It's okay to step forward and speak to what kind of protections are in place. Somebody says, I want to say something, but I'm really afraid I'm going to get caught. There's going to be retaliation. How would you respond to that?
Yeah, there are whistleblower protections for individuals who ring the bell on fraud. They cannot be retaliated against. And if they are, they can bring claims against their employer for retaliating against them, particularly if it's related to their free speech and protected speech, and if they're identifying fraud. Oftentimes, whistleblowers are retaliated against, but we encourage them and we want them to come forward, and we reward them when they do. Right. And if they're in an environment where fraud is being encouraged and allowed to proceed, they need to get out of that environment.
For sure.
But you can do a lot of good by protecting the United States Treasury, by blowing the whistle on fraud and filing a case, or just bring it to the Department of Justice. Bring us the evidence and we'll investigate, and you don't have to put yourself out there and file that case.
And I think bravery encourages bravery, right? Like, if it's somebody speaks up and somebody else says, wow, that's kind of behavior that I should emulate, right? And people don't seem to realize that it's your money. The federal government is spending somebody else's money. That is your money that should be protected. And it's like a further incentive to speak up and be heard, so to speak.
In two areas where I think your viewers may be interested in knowing, like, how we're using the False Claims Act. So the Civil Division has always done healthcare fraud and procurement fraud, but we've tried to use the False Claims Act to advance the president's priorities. And two of the priorities that we have are discriminatory practices in corporate America, where you have corporations, who take government money and have certified that they are complying with the civil rights laws. And in fact, they're not. They're making claims against the government is contracting with them, paying them money, and they're lying to the government and saying, we're treating everybody equally, and when in fact they're not. And the evidence that we're seeing is damning, and we're continuing to investigate. We've announced one settlement with IBM. There will be more in the pipeline, and those are cases where there will be whistleblowers.
Right.
And we encourage those folks to come forward if they know in the past that they worked for a company that was having illegal DEI programs, or those programs are still going on under the guise of different nomenclature, then please blow the whistle on those companies. Another area where we're using the False Claims Act is to investigate hospitals that have been providing so-called gender-affirming care, or providing transgender services to kids,
Right.
and making false billing codes and seeking compensation from the government and lying about the care that they've been providing and claiming that it's been legitimate services when they have not been. So we're still in the early stages of those investigations, but the False Claims Act is an important tool as part of those investigations.
I mean, that seems to me to be pretty righteous work, because as I recall, one of the elements on the False Claims Act is materiality, right? And some critic might say, well, what is the government's business about any of the DEI practices from a contractor who is, making whatever product or whatever service for the government? What difference does it make if they employ, racial set-asides or other things with their employment practices? But in fact, it's been the case for decades and decades, that the government requires that you comply with, applicable federal laws, which include Title VII, which include all of these things that say you cannot discriminate against employees based on their race. And so as a hypothetical, if you had a government contractor that said, I'm only going to hire white people to do our work, where no other groups of people can apply, they're not going to be hired, whatever, and I'm the best contractor that there's ever been, that there would, of course, they would never get a contract, because the government would look at their workforce, they would see what was happening, or they would get allegations. Oh, of course, I'm not going to give you this work. You're blatantly discriminating against people, right? So when the shoe's on the other foot, and the thing is, oh, well, we want to racially balance our workforce, we want to do these other things. Of course, it's a material element of the contract, because the government has an interest in ensuring compliance with, things like Title VI, Title VII, or the contractors comply with Title VII. Of course, the government, different interest with Title VII, but with Title VI, with other issues that are coming along. And so, can you speak to that materiality requirement, especially when it comes to these two areas that you just covered? Because the fraudulent billing practices also is really, it seems very common sense to me. Like if you've put in the wrong code to advance some agenda in your billing for some service, and you're saying, hey, they're getting, I don't know, like some kind of muscle corrected in their chest, when in reality they're slicing off a young girl's breasts or something. That seems to me to be pretty obvious of something that should be done.
Right. Could agree more. Think about it in the procurement space.
Right.
When you have a contractor who has always signed a contract that says we comply with the civil rights laws and we don't discriminate on the basis of race or sex. And if they were committing flagrant violations, then that would be a breach of the contract.
Right.
They wouldn't be living up to their obligations, and we wouldn't pay them.
Right.
And so that's what was happening over the last 5-6 years.
Yeah.
So it's material, number one, because the contract terms require certification that you're not discriminating on the basis of race and sex. And if we had known that, we wouldn't have paid you, and we wouldn't have hired you. Second, think, just to use a hypothetical example, think about a government contractor in the national security space. The government, we want to buy products that are made by the people who are talented and that are the best products at the best price. We don't want contractors who are hiring less qualified people that are increasing prices.
Right.
That hurts the taxpayers, and we're paying more for less efficient products.
Yeah.
Right. So there's really a good government principle here that we want the government to be purchasing good products at the lowest price. And when companies are discriminating on the basis of race and sex and they're not hiring most qualified people, that affects the taxpayer, and it's fraud on the government.
Yeah. So let's shift gears just a little bit, because when I first started working with you, it was in the first Trump administration, and you were in the federal programs branch. And so now you're the head of the entire civil division. So what have you seen change between the first term and the second term, particularly when it comes to working at the department, particularly when it comes to some of the injunctions that the American people see every day, or just general litigation across the government, across the country, relating to the president's agenda?
Yeah. It's a great question. A lot of things have changed. I'll say three things that really stand out to me. Number one, personnel. When we started in the first Trump admin in 2017, there had been 8 years of the Obama administration. And so a lot of people had not served in government. So a lot of folks like me who came into the government in 2017 for the first time had no experience, and we were building the airplane on the fly, and we were learning how government works, and it was just a different time back then. Fast forward to 2025, a lot of folks like you and me who started in the admin last year had experience in government. So you had this personnel base that had experience, that had 4 years to prepare to take power, and knew how the levers of power worked. And we came in with a plan. We staffed up on day one. We executed on that plan, and you were a big part of that. So I think that was a big difference, is we knew what to do from day one, and we had personnel in place, and we had a plan. So that's different. Number two, much faster paced. The intensity is just a much higher level, both the pace of decision making and the pace of litigation. Whereas, you issued a lot of executive orders in Trump 1. In Trump 2, there's been hundreds now. So, and the agencies are doing their things as well, and everything's getting challenged. Right. Everything was challenged in Trump 1. In Trump 2, everything gets challenged 3 or 4 times now. So, the pace is much faster. In Trump 1, it was preliminary injunction motions and ordinary briefing schedules, and things move quickly, but not at the pace they are now. At the pace they are now, everything's in a temporary restraining order, and we have to do emergency appeals all the way to the Supreme Court. So just the pace of things is way faster than I recall it was in the first term. And then third, we're way more aggressive now. We have to be to counteract the lawfare and the resistance we see around the country. And so, you see things like us going to the Supreme Court 25 times and probably winning 23 of those times.
Right.
Because we just have to. If we don't immediately appeal a temporary restraining order that's going to block the president's policy from going into effect for a year and a half, then that's time on the clock that we're losing. I think we learned a lot during the first term that we can't let the nonprofit organizations and the states and the judges hold up the president's agenda and prevent that from going into effect. We have to be aggressive and fight fire with fire. And that means, not being afraid to lose. And sometimes we lose on appeal, but that's okay. We're going to be aggressive. And I think that's worked for us.
Yeah, that makes sense. And I think there's a sense of urgency. I feel, I'm not even, at the department, you feel this sense of time is not on our side. And we have to do right for the president's agenda as quickly as we can, because the other side, they never sleep, right? They're at it 24/7 and they're focused. So in between Trump 1 and Trump 2, of course, we had the Biden administration, and they're hiring all sorts of careers and politicos for the Department of Justice. How do you, when you come in and you know that there are people there who are diametrically opposed to the president's agenda, whose job it is for you to enforce and carry forth and defend his agenda, how do you handle that?
Great question. A lot of people started fleeing out of the Justice Department as soon as the president got reelected. So the attrition numbers started almost immediately. And there's been attrition throughout DOJ, every division, every U.S. Attorney's office. But I would say by last summer, things really stabilized in the civil division. The people that didn't want to be there left within the first 6 months. And the people that are still with us really, really want to work with us and want to advance our agenda and are doing hard things for us and are working on really hard cases and are getting yelled at by judges and are, doing really hard things. And that is the epitome of the right kind of career employee. It doesn't matter what presidential administration is in power. The job is to advance the policy, defend the policy, and take direction from the political appointees. And so we've got phenomenal managers still in the civil division. We're hiring up new attorneys, but we've got a ton of career attorneys who are still with us. So contrary to the reports that you read in the news, DOJ is stable and strong, and we're still having folks join us every day and applying to us every day. So given the onslaught of litigation that we face, we're continuing to hire up, and we need more people to join us. We can do more enforcement. We can do more denaturalization cases. But I've had great experiences with the career folks in the civil division over the last year and a half.
So that's a perfect segue to denaturalization cases. But before, it's funny the comment you made about the media, because we all see it every day. They never let the truth get in the way of their agenda, right?
Exactly.
So speak to the denaturalization cases. how you're working on all that.
Yeah. So just to educate the viewers, a denaturalization case is a case where somebody who was a naturalized citizen who foreign born came to the United States lawfully and applies for citizenship. And during that process, they lie about some material fact related to their background. Might be their criminal history or the fact that they engaged in war crimes or were part of a foreign military, whatever the case may be. If they misrepresent their anything during the naturalization process, that can be a basis for us to file a civil lawsuit asking a judge to find that the elements of civil denaturalization are met, and then stripping them of revoking their citizenship certificate, and then they're here in the United States illegally, and then DHS can remove them from the United States. As you remember, this was a priority during the first Trump administration. We stood up a whole unit in the civil division to do this work. It's really righteous work because it is immigration fraud, right? These are individuals who lie to obtain citizenship, which is the most valuable benefit we can offer somebody, and all the benefits that attend to United States citizenship and the other benefits that flow from it, including voting. So DHS has done a great job in identifying people who are subject to denaturalization. That's what they do. They do the investigations and they send over files to DOJ. What's shocking is that work just screeched to a halt during the Biden administration. They just put it on the shelf and they put up bureaucratic obstacles and they just refused to file righteous cases involving sexual abusers, war criminals, criminal spies against the United States. These are people that we willingly turn a blind eye and let us stay in our country.
But then again, look at the border. It's like you fling open the doors to our country, which is 100% what they did from the minute that guy got in, to the end of the Biden administration. To me, it's totally in keeping with the behavior, right?
It is part and parcel of a refusal to enforce the immigration laws. Exactly. And this is one, I think, that went under the radar, and we're reviving it. And we've made it a priority since last year, and we've really pumped up our efforts this year under Todd Blanche to clear the backlog of cases that DHS has sent to us. And I think our goal is to clear out that backlog and file hundreds of cases by the end of October this year. We've already filed dozens and dozens of cases. I think 70 or 80 cases so far just this year, and we're going to file many more.
Well, I mean, like you said, it is very righteous work, and the fact that the last team didn't engage in it should shock the conscience, because if you're an American citizen, as you said, citizenship is the highest honor that any country could bestow upon someone who is not a member of that country's, political body. And so this is the ultimate thing. And so in a parallel context, if you had a situation where there was a young couple and they fell in love and they go and they decide to get married, right? And they get married and everything seems hunky-dory. And a couple years down the line, the wife starts finding out, oh, wait, you did what? And find out that this guy was someone who he completely misrepresented who he was. Maybe he was some hardened criminal. Maybe he was a gangbanger. Who knows? You could imagine any set of hypothetical scenarios. I think every right-minded American would say, well, of course the woman would be justified to be mad about the situation and to want to dissolve the union, depending on the stuff that happened, because the guy lied. Because the guy lied about who he was. He lied about his past. And the fact that some people in our society can't recognize that kind of common principle and apply it that they would apply in their own life for their own family members or their own friends, and carry it forward to one of the most important things that we could have as a group of people, the American people, citizenship, that somehow it's even remotely controversial. It seems crazy to me.
It's crazy, Gina. And what we've tried to do is really publicize these cases. When we file them, we issue press releases and describe the facts. And these aren't people who got a parking ticket and lied about it. These are people who are war criminals and spies and abusing children and committing identity fraud, really bad things.
Right.
And they should not be in our country. They should not have the benefit of citizenship. And I think the righteous indignation that you described, I married this person and they weren't who we thought they were.
Right.
We should take that benefit away from them, and they should not be part of our country.
So I want to, you guys get criticized a lot by the media, by nonprofit organizations, by judges, by everyone in between. One type of criticism that I would like to ask you about in particular is there's been this narrative that a few judges have started to talk about. And I'm not going to ask you about any particular cases or any particular matters, but this whole narrative that somehow this presumption of regularity that is supposed to apply to the court's interpretations of the way the government operates is being eroded because of the actions of this administration, that somehow, or because of the actions of a individual lawyer in the civil division trying to defend a case or trying to defend something, that somehow, because the judge just disagrees with the policy or disagrees with the outcome, or because they don't have perfect facts at a point in time when something is very fast-paced, moving along rapidly, that somehow that's going to erode the presumption of regularity of what the government's just trying to do, which is to execute the laws. Can you comment on that at all and kind of talk about how that, the history and kind of what you perceive going forward?
Yeah. So the history is, in the case law, there's a lengthy line of cases that talk about how the government is entitled to a presumption of regularity. The government is held to a higher standard. We trust the judges, trust the government to do the right thing. We pursue justice. We don't just try to win at all costs. And so that benefits the government a lot, that judges take our word for it. But I think, and what we've seen is, and I think it's telling, is that you really only see it in the high-profile political cases involving the presidential decisions or presidential priorities. And it's oftentimes judges in particular districts around the country. And so what they'll do is look at on the face of the policy and just think this is unreasonable, and this can't be lawful. And the case starts out with, well, we're not going to trust, I can't trust the government because this policy is unreasonable, it's racist, it's bigoted, the president is racist, so we can't trust anything that they do. And that bleeds over from the policymakers to the litigators who have the job of writing the briefs and defending the cases in court. And the judges will often take that anger out on my lawyers. And it's really unfair. And it's incredibly dispiriting to see judges behave that way. It's not fair to my attorneys, and it's not fair to the president or the agency decision makers. And oftentimes what judges will do is, set impossible deadlines or impose impossible requirements. And then we at the department or our agency clients do the best they can to comply with those deadlines or whatever those requirements are. And then the judges are setting us up for failure. Yeah. And so then it's kind of a reinforcing narrative that, well, the government's not complying with orders, or, not doing the right thing. So I think it's telling, and your viewers should think about, well, when you hear that in the media, well, what kind of case is it? Well, it's an immigration case. It's in certain districts. Certain repeat judges tend to just have the same views on the president's policies and this Department of Justice. So we try to tune all that out. And like going back to the point about the career attorneys, like they are handling the majority of these cases.
Right.
And they are going into very hostile district courts and defending policies that they probably didn't vote for and don't support. But the role of a Department of Justice attorney is to set that aside. We're not the policymakers. Our job is to defend the administration's priorities and protect the executive branch and its policymaking prerogatives. And oftentimes that means we get yelled at, and we just have to oftentimes take it. And we often know that we're going to win on appeal.
It's always struck me, and this might go back a while, but it just strikes me as a little bit absurd when you think about it. A particular district court judge sitting in any district across the country, ordering, say, a cabinet level official, all right, by Tuesday, you're going to come in here and you're going to testify as though this person has nothing else to do in their life but care about what this particular district court judge wants or thinks is happening with a particular situation, with no concept of how the executive branch even functions, and the level of disrespect that shows, the level of kind of Article 3 supremacy mindset here, that somehow the executive branch is subservient to the judicial branch, or that the legislative branch is subservient to the judicial branch, strikes me as being not, it's not necessarily, it's anti-constitutional, it's anti-structural, it's not what our founders set up. I mean, it strikes me as something that is very problematic and hard to deal with on a practical level day by day, because again, you have someone, maybe they're a political appointee, maybe they're not, but they're going in and they're getting yelled at by a judge who has this preconceived notion of what's going on with this particular case, and is just, all right, by Monday you're going to come in and you're going to have a 30-page brief defending this, and I'm going to question the cabinet secretary, and your firstborn child is going to have to attend with you, and you're going to have to wear a purple polka dot suit, with a striped tie, putting all these impossible conditions on the lawyer. And then when it doesn't happen, of course, the media response is, judge blows up at DOJ not complying with order. And you just like, this was an impossible thing to comply with to begin with. I mean, how do you deal with that?
Well, it helps to have experience that, like, we've seen it all by now. And so, if it's your first time before a judge that is giving you a hard time, it's tough. And it helps to talk with people who are experienced and who've lived through this. And it's like, it's deja vu all over again, with every case. District judges have immense power to run their courtrooms, to set deadlines. And, 99% of what they do is not reviewable by a higher court. And so we just have to do the best we can to meet the deadlines and make our arguments, build our record, and understand that we're going to take our lumps in district court, but that's our job, and we're going to hand it off to the appellate lawyers, and they're going to win. We're going to hand it off to John Sauer, our Solicitor General, and he's going to win in the Supreme Court. But it's our job not to be intimidated and to fight. We can't be intimidated, or we're a co-equal branch of government. And yes, we will comply with all court orders, and yes, we will aggressively defend the president's prerogatives and the executive branch's prerogatives, but we're a co-equal branch, and we will make our record, and we will do the best we can. And oftentimes, we get that criticism because we don't bow to the will of district judges who want us to concede, yes, it's unlawful, I don't support this. But that's not our job. That would be contrary to our job. Our job is to zealously advocate for our clients,
right,
and defend our clients, even though oftentimes in a lot of these district courts, we're fighting both the plaintiffs and the judges, and the deck feels stacked against us. But I think our record of success on appeal has proven that the aggressive strategy that I was talking about earlier is winning the long game. And the long game is allowing the president's policies to take effect. Even if that means, we lose a lot of cases, we're also ensuring his policies go into effect.
Well, and that focus and that fortitude is what you need. And you clearly have it, and to act as a mentor so that seeps down to the younger attorneys is crucial. And it certainly doesn't help that when the plaintiffs forum shop, right, like they go specifically to certain states that they know they're going to have empathetic judges who really, it's to some degree they may not be aware, as you said, but there's also a blatant disregard for the law. Like they're in charge, they're the ones in the black robe, and so it's their sort of kingdom, and you just have to fight through it and appeal, and that's the focus and fortitude that you exhibit, and that's crucial.
One of the things touching on that is this concept of zealous advocacy. And you've worked in the private sector, of course. You've worked for a law firm, it's always also one of these things that just struck me as odd is the whole notion that in the private sector with a firm, everyone understands the concept of zealously advocating for a client. Hey, maybe I love my client, maybe I don't, but your job, your responsibility is to zealously advocate for their interests and to seek what's best for them, and to pursue victory for them, whatever that looks like in that particular case. And then the notion that there's something wrong with the Department of Justice zealously advocating for the president's interests has always struck me as very odd as a legal matter, as a conceptual matter, because that is, in fact, the basic responsibility of every lawyer across the United States when it comes to representing a client.
It's exactly right. The same duty that private lawyers have to zealously defend their client and advocate for their client applies to DOJ lawyers. And what that looks like is, we have to make every reasonable argument we can make to defend a policy, even if we don't like it,
right,
or even if people down the line don't support it. And we're doing that. What's a little bit different is, in the private sector, if a client tells you make this argument or do something, you do it. At the DOJ, it's a little different, right? Because when we make appeal decisions, for example, we're looking out for the United States as a whole. So we might have an agency that took a bad loss in district court or really wants to appeal, but it's in a bad court, and we decide, it's just not in our broader interest to appeal that, might get a bad precedent, something like that. So in that case, we sometimes we'll tell our client agency, it's better not to appeal this. And even though you want to, we're not going to appeal it. But the advocacy and the zealous representation still applies to us regardless. We're always trying to advance the president's agenda.
So I have a question that I like to ask everybody, or I try to ask everybody. Sometimes I forget. If you're giving advice to a young lawyer who wants to be a litigator, they want to go work for the Department of Justice, they want to go do something that's going to make a difference, what advice would you give to them about pursuing a career with meaning and with fulfillment and working even at the Department of Justice in the Civil Division?
So the first thing that comes to mind is don't be scared to take risks in your career. Most young attorneys, they're going to work as a lawyer for 40 years. And you don't have to stay in one place for all those 40 years. You can do different things. You can do exciting things. Over my career, I probably reinvented myself every 5 years. You kind of take a new job. The market changes. I've been in private practice. I've been in government a few times now. Taking this job was a risk. I could have stayed at a law firm and, been very content, but I wouldn't be as fulfilled as I am now doing what I'm doing. And this job takes risks. We have a lot of arrows coming in, incoming a lot. But it's fulfilling to be with, people I like and trust, and the camaraderie at the department. We're advancing a mission that I'm fully supportive of, making America safe again. And working on the most interesting and exciting cases in the courts, right? Every case that we work on every day is in, front page news somewhere in the United States. And it's very exciting. So that's one piece of career advice I like to give is don't be afraid to take risks. You may be very comfortable and safe at the law firm or wherever you are. And it may seem like a risk to take a step back to go into government, but you got to be willing to take a risk if you're not happy and you want to grow your career. It can be boring to do the same thing all the time. If you don't take risks, you don't get rewards. So I encourage people to do that.
Yeah, that makes sense. And it even makes sense to take the risk when you are happy where you are, right?
Yeah.
To try something new, get out of your comfort zone. I know when people interview at AFL and they want to work for us, and they come from a law firm where they've clerked or whatever, and for them, they say they understand that it's about the mission, that it's not just about this particular client in this particular case, but it's about the overall mission and paying it forward. And I think that's something like really important to the attorneys at AFL, that what we're doing today, we understand that to some degree we're custodians, if you will, of the mission, and that we want to be a part of it and to pay it forward.
The mission is so important. Believing in what you're doing and believing in that you're doing good and advancing a righteous cause. And working in law firms is great. I've worked in law firms and I've worked with some great clients, but there's something about being in government, being part of the mission of an agency or at the White House, where you're part of something bigger than yourself. You're not doing this for your own enrichment, your own gain. You're doing it because you believe in the cause, and it's exciting to get up every day and just fight as hard as you can, and then go to sleep and do it the next day. So one other just thought on that is, there's a window right now for folks to come into the government and work for the Trump administration, but that window will close. It is time limited. And I remember when I graduated law school in 2006, I clerked until 2007. So it was the last year of the Bush administration, and I did not serve in the Bush admin. And then we had 8 years of the Obama administration. So there just weren't opportunities for conservative Republican lawyers to serve in government for 8 years. And who knows what's going to happen after this administration. So if you're at the right stage of your career, think about coming in now. Now's the chance to punch your ticket. We're always looking for good people, and you're going to get a great experience.
That's great. So Brett, we talked about a number of things here, general advice for young lawyers, but why should a young lawyer come work for the Department of Justice, the Civil Division in particular?
So working at DOJ is just a fantastic experience. If you're a young lawyer, I think couple reasons you want to think about why it might be attractive for you to come to DOJ. Number one, you're going to have your own cases and you're going to get into court and you're going to get the type of experiences you can't get at a law firm. We have so many cases, so many high profile cases that we're looking for people who want to be first chair lawyers. And that's really hard to get experience in court and taking the lead on cases if you're in a law firm in particular. So, we're hiring folks, we're giving them cases and they're arguing those cases in their first week. Number two, just like the mission. There's something about being in the department, everybody rowing the same direction and advancing the same mission. It's not about you, the individual. It's about advancing the mission of the department and the administration. And the people you meet will be lifelong friends. Like I met you in 2017 and that relationship has been a wonderful blessing to me. And I've met so many people like you working in government, both career and political, that are going to be lifelong friends. You can meet great people in the private sector as well, but there's something about being in the trenches, working together, that is just so rewarding to have people you like and you trust, that you're all fighting together and you're not in it for yourselves or your own profit. You're in it because you support the policies and the agenda and the mission. So, if you're a young lawyer, all DOJ components, I think, are hiring, whether you want to do civil litigation or antitrust or environmental, civil rights division. I think one of the coolest things I've seen recently is Harmeet Dillon, our AAG for the Civil Rights Division. I think you've had her on the show. She is swearing in for all of her new career attorneys that she's hired over the last year and a half. And there's something like, I don't want to undersell. I think I saw like 75 attorneys.
That's awesome.
It was incredible. All in the Great Hall at DOJ. They did a big photo, so I encourage folks to go see that photo. But I mean, just that is such an inspiration to me. And I would love to copy Harmeet and do something like that at some point. But to see people who are excited to join the department, and contrary to what the media says, like people are joining like every day and joining not just Main Justice, but U.S. attorneys across the country to prosecute crimes and do really exciting work. So now is the time to join.
That's awesome. Well, Brett, look, I know you're a busy guy. You've got a lot of injunctions to go defend, I'm sure, or to stop or to appeal. So we appreciate your time. We appreciate everything that you're doing for the country. If you're a young lawyer, I hope that you've listened to him and you understand the importance of actually getting in the fight and trying to do something that's bigger than yourself. And so it sounds like there's probably a lot of opportunities at the Department of Justice right now. If you're so interested, check it out. In the meantime, thank you, sir, for your service. Thank you for being here today, and we look forward to seeing you soon.
Thank you, Chief.
Thanks.
Thank you.
Thank you. That's great.
All right, it's time for this week's Bad Legal Take.
From viral bad arguments to headline mistakes, we're calling them out on Bad Legal Takes.
All right, so for this week's Bad Legal Take, I think we have a particular situation that you should all be familiar with from if you've been awake over the last 4 to 5 years. And it relates to one Matthew Colangelo. So, Julie, what you got?
So we just sat and had a conversation with the gentleman who so represents the goodness, if you will, of what is the Department of Justice. So Mr. Colangelo, who was the acting Associate Attorney General of the United States, the Civil Division under the Biden administration, exemplifies the complete opposite. I don't know whether I would say it's a bad legal take as much as it is just bad lawyering and dishonest lawyering. Here's a man who said he had no involvement in going after President Trump during the Biden administration and all its very nefarious actions, including when D.A. Bragg went after the president, his 34 counts of violating NARA and so forth. So Colangelo denied any involvement. And of course, the media defended and said, why would somebody who's head of the civil division be involved in criminal prosecution? So AFL decided to do its own investigation and check out Colangelo because we knew something was up. And we engaged in major oversight. And what did we uncover? We uncovered major contradictions in what he said, what Colangelo said he did and did not do, versus his very, very hands-on involvement in going after President Trump. What did that include? Something like 36 touch points with Bragg and the White House counsel's office And he actually did what? Didn't he give the opening statement, Gene, in the in DA Bragg's case against the president in the Nara case?
Yeah, absolutely. Yeah, but it's Julie, it's crazy. I mean, it's a bad factual take for him, in particular in the scenario, but it's also a bad legal take because the whole notion, where if you recall, for a number of years now, the media, or at least especially during the Biden administration, ran this playbook, which was there was no grand conspiracy against the president. These were all objective, independent investigations, right? Oh, we're just looking at what, the president did here. Oh, this thing is just looking at the president for this. Oh, and this thing, and they just so happen to all occur at the exact same time. And there was absolutely no coincidence. There's no connections between any of them, and that there was no grand conspiracy to deprive the president of his rights. And these records, I think that you're talking about, directly contradict this notion that he had nothing to do with any targeting of Donald Trump. And in quite frankly, I mean, the more that you dig into these things and the ties and the circumstances and the timelines, you toss in Georgia as another one into this, and Fani Willis and her boyfriend, and coming up to the White House for meetings with counsel. All of this, the American people are not dumb, right? They're not dumb. They can see the fact patterns. They can look at these things and they can evaluate it the same way that they would as responses from their kids. When you're a parent and you just know what's going on, the situation, you look at the facts, you look at the evidence, you can ask for an explanation, but this whole idea that there was no nefarious activity going on behind the scenes has to be one of the biggest misunderstandings or intentional misunderstandings that has ever been perpetrated on the American people.
I think one of the shocking elements, to me at least, is that to stand in front of a camera and say, I did not do X, and then you see the actual emails, the nerve, the temerity to say, I did not, and then you actually see, you can, like every picture tells a story. It's right there, what AFL uncovered and is continuing to uncover, not just with Colangelo, but so many other instances with the Biden administration, is so shocking, the nerve. And then you had the Attorney General of the United States, Garland, denying that Colangelo was involved. So are you telling me that the guy was not in the office at the time that Colangelo had been involved in all this activity? Or was there a lack of honesty? I mean, people can make that decision for themselves. Right. But we know that many, many times during the Biden administration, either the president, the White House counsel's office, the AG said X, and through AFL oversight, it was Y and Z. It's just so shocking that there was such a blatant, not just disregard for the truth and for lawyering, but for the American people. To be so dishonest is really beyond the pale.
Yeah, absolutely. Well, look, that's going to do it for this week's episode. I hope that you enjoyed our discussion with Brett Shumate, a great patriot, great American. Julie, thanks for bringing up this example. It's great. We'll see you all next week. We're going to have another exciting guest. Interesting legal topics, interesting issues to discuss. And until next time, see you soon.